Hi, everyone. Thanks so much for joining us today for our Hot Topics webinar. We're so excited to be with so many of you. As some of you know, Farnaz and I started this webinar about 3 years ago after we were both in-house counsel at universities with this idea that we wanted to think about what would be helpful if we were in your shoes at universities thinking about new developments in the law. And we try to structure this in a very practical way, which is we give a high-level overview of several different areas and then try to give practical advice related to each of those areas. And we also always try to have a guest speaker with us today. And today we are lucky to have three, our wonderful colleagues, Brian, Mike, and Mindy, who will talk about topics that are pertinent to you. We did not have to stretch very far to try to find some topics to talk about today. We're really grateful that you all are spending this time with us as you try to navigate your campus partners through what is a very difficult and stressful and evolving time on your campuses and in your legal offices. As I mentioned, we do high-level overviews. This is not meant to be an in-depth dive on particular topics. We are actually in the midst right now of doing a deep dive on the topic of DEI. Brian is spearheading that effort. That's why we asked him to talk about DEI along with Farnaz here today. The next and final installment in that webinar series is next week on February 26th. And Brian and I are going to be presenting together on DEI programming, including how to weigh and reduce risks in your DEI programming. So I think a lot of you are probably interested in that. We will send a link to register for that webinar if you're interested in coming. We've also already covered the executive order that Brian will speak about, and then litigation trends related to DEI was the topic next week. And you can find recordings of those webinars online if you're interested. But please do join us next week for our programming on DEI programs and risk related there too. We think we're probably not going to have a ton of time for questions today. Please put the questions in anyway. We will get to whatever we can. And if we can't get to your question today, someone will follow up with you after the webinar over email or with a phone call if you prefer. But with that, I'm going to go ahead and turn it over to Brian, who's going to tackle our first topic today. Thanks so much.
Thank you, Sarah, and hello, everybody. So as Sarah indicated, I'm going to kick off our discussion on hot topics with an overview of an executive order, of the hundreds of executive orders that have come out in the last few weeks. This one in particular is entitled Ending Illegal Discrimination and Restoring Merit-Based Opportunity. Goodness, there's been a lot of chatter about this particular executive order in the press, some of which is accurate, most of which is not. And as a result, there's been a good bit of confusion. So we're going to hit the highlights for you and then give you a couple things to think about as you return back to your day. So if you hadn't been paying attention, there was a new executive order that came out, goodness, almost a month ago. It was signed on the 21st of January and posted the next day online. There are links here to the executive order itself, plus a summary that we published earlier. And really, when you think about the order itself, it does really 5 things. When you read it, it sort of goes on and on. It's a little bit confusing. But the focus is really on a couple of items, some of which apply to some of you, and a couple of which apply to all of you. The first thing it does is it revokes something called Executive Order 11246, which deals with federal affirmative action for minorities and women. This is an executive order that's been around since the Johnson administration. You live by the executive order pen, you die by the pen, and it's automatically revoked. Related to that, it ends all the investigation and enforcement authority related to Executive Order 11246. So there was an agency, the Office of Federal Contract Compliance Programs, which is a sub-agency of the Department of Labor. It does audit and litigation enforcement relating to, among other things, women and minority affirmative action plans for federal contractors and subcontractors. All of those audits, all of that litigation, automatically over. In addition, though, even if you're not a federal contractor, it does a bunch of other things. It creates brand new federal enforcement authority and focus on DE&I initiatives generally, whether you're a federal contractor or non-contractor. That includes in the private sector and in higher education specifically. Related to that, it tells agencies, including the Department of Education, but all federal agencies, that they're supposed to come up with a federal enforcement target list. that are going to report up to the Attorney General for reporting and enforcement action later. Farnaz and Sarah are going to talk about that some more, but basically the idea behind it is, unlike some agencies like EEOC, DOL, et cetera, that wait for complainants to come to them, they're not going to wait. They're going to draw up proactive enforcement targets for agency action. So that's very unique. And then it's got unique flow down requirements, speaking of unique, related to DE&I efforts that are going to be flowed to federal contractors and subcontractors. And the reason they're doing that, as we're going to talk about later, is to sort of increase risk related to False Claims Act litigation that comes from it. So that's the 5 things it does. It gets rid of the Executive Order 11246. It kills the related audit enforcement authority. It adds new priorities around DE&I. Then it has related flow down obligations and contracts, all in one executive order. So what's the immediate impact? Well, if you're a federal contractor or subcontractor, like a lot of schools are, what this means for you immediately is that you no longer have a requirement to do minority and women affirmative action plans. And that includes all the related sort of regulatory requirements that go with it regarding outreach and statistical analytics, sort of workforce demographic sort of profiling, compensation analyses, hiring, promotion, termination, disparate impact analyses, all of the bulk of affirmative action. When you think about your plans, all of that is gone, assuming you were previously covered to begin with. What is not gone, if you're a federal contractor or subcontractor still, is the veterans and disabled part of affirmative action programs. They remain. And you might ask yourself, how can that be? That's because the executive order was a presidential executive order, 11246, and it's gone. But the other parts of affirmative action that deal with veterans and disabled individuals, they're under something called VEVRA and the Rehab Act of 1974. And those actions are statutes and cannot be amended without legislative action. And so that may still be on the table, we'll see. But for now, those requirements remain. The interesting thing, though, is the enforcement of VEVRA and disabled individual affirmative action plans are technically in abeyance right now per DOL. And they'll probably produce some additional guidance on that, hopefully in the next few weeks, about the status of ongoing audits and activity. Likewise, things like EEO1 reporting, VETS 4212 reporting, and similar state law reporting, if you think about pay equity reporting in California, Illinois, things of that nature, they all remain. So what about non-contractors, and contractors? What else do you need to think about? Well, when you think about the core parts of affirmative action and a lot of the things that people do in the name of DE&I, one big change is certainly that the legal environment about things like the use of aspirational goals, boy, that's changed a lot. It's changed in part because there's always been a tension since the beginning of the Civil Rights Act about when people can use goals and how those goals turn into unlawful quotas. And the law has always been that you can have aspirational goals that you shoot for with respect to demographics and hiring and other circumstances. And you can do things where you look at pipeline development and outreach and barriers to sort of entry and things that help people retain and thrive at a workplace. All those things have always been lawful under Title VII and other laws, and they remain lawful. But what's always been unlawful is that you cannot hire by the numbers. And so you cannot use race, sex, gender, national origin, et cetera, to make selection decisions. And that tension has always been there. You can have goals, but you cannot have quotas. And what's definitely clear right now with the new executive order is agencies are going to be looking at this a lot harder. And likewise, if you were a federal contractor before, when you establish goals, frankly, you had some regulatory cover, right? If somebody said, why are you doing a goal? Why are you setting this? The short answer is, I'm required to as a federal contractor and subcontractor. That cover is no longer there. And therefore, you need to sort of reassess your legal risk related to the use of goals. Likewise, the legal risk related to DE&I programming generally is also on the crosshairs of pretty much every federal enforcement agency. So what does that mean as a practical matter? Well, first off, it's going to be a good thing in some respects. You're no longer required to do the most burdensome part of affirmative action if you're a federal contractor or subcontractor. And with that, you can think about what you want to continue. Do you want to repurpose that money, that time, that expense, that staff to other things? Do you want to change the way you do your analyses? Do you want to continue to do some analyses? Frankly, there are pros and cons to a lot of that, and there are some legal risks that we should all talk about related to the nature of ongoing sort of reporting. But as a regulatory requirement, things you must do, that is gone. And that probably is a positive thing. The other thing that's positive is certainly nothing about this gets rid of general non-discrimination law. The only thing that's gone is, quote, the affirmative action part of it, that sort of self-reflective sort of requirement to conduct and do affirmative action plans for minorities and women. That is gone. The non-discrimination parts remain under Title VII and everything else. But boy, there are new legal risks that come with all that. That's the negative. So what's one legal risk? Farnaz and Sarah are going to talk about this some more, but there are now flow down requirements that will be included in new federal contracts. They haven't hit the fan yet because the FAR Regulatory Council has not issued them, but we expect to see terms like this show up in federal contracts, subcontracts, and grants in higher ed pretty soon. One requirement is that you have to sort of raise your hand and, quote, agree that you're complying in all respects with applicable federal anti-discrimination law. And you're agreeing also that it's a, quote, immaterial impact, a material element of the contract, which is frankly an attempt to sort of put higher ed and other employers in the crosshairs for False Claims Act litigation. But related to that, you must also, quote, certify that your programming related to DE&I do not violate applicable federal anti-discrimination law as well. This matter, frankly, is in litigation right now in Maryland court, and there's injunction hearings about this going on this very week. So we'll see if this part actually stays. But that's sort of one key element of the new executive order that has potential sort of negative flowback impacts writ large. The other thing certainly is federal enforcement action in this area is also refocused, shall we say. And you'll see a couple of things like this from a variety of different sections. Farnaz and Sarah are going to talk about the Dear Colleague letter that just went out from the Department of Education, Office of Civil Rights. But here are two examples from some other agencies. One quote from the new EEOC chair, one quote from the new Attorney General. And basically, their spin on this is, look, from their perspective, they believe that certain actions in the past related to DE&I in particular have gone unenforced, either by sort of just the sheer weight of volume of what the agency has to deal with or by inattention. And they're saying that's no longer the case. To the extent that people come to us with claims regarding DE&I or affirmative action, to the extent that we see things on our own that we think warrants action even without a complaint, they're basically putting employers on notice that you need to pay attention because they're paying attention. And so what should you be thinking about immediately? Well, if you're thinking about enforcement action, either on the plaintiff side or on the agency side, just bear in mind that where they're going to start is with low-hanging fruit. And what I mean by that is they're going to be looking at things that you self-describe, things that you self-report on things like ESG and sustainability reports, or on your career page, or on your admissions page, or in other sort of sectors that you sort of publicly pronounce in press releases or videos or anything else. And they're going to be looking at that information to determine if you ought to be a target for their own enforcement action. And so what we've been spending a lot of time with clients doing is thinking about, okay, separate from what we're doing on the ground is how we're describing it. Does it need to be caveated? Does it need to be changed in some way? Does it need to be clipped? And do we need to sort of clarify the good work that we're doing in this space and what's clearly lawful from what's potentially unlawful? And so I think that's the thing that if I was in your shoes, I'd put at the top of the batting order. Just one example of the weird environment we're in. I had a client the other day that sent out an HRIS alert to all employees that simply asked them to go online into their HRIS system and update their personal information. That includes name and address and where they like their checks sent to. It also includes EEO and other information. And that client got 4 complaints from employees about simply trying to update their demographic information. It was perfectly lawful, perfectly reasonable request. But could they have sort of explained it a little bit more upfront to employees about why they were doing it? Maybe. So that's the only thing I would say. Just, you don't have to scrap your programming. Nothing about the law here requires you to sort of scrap everything you're doing in this space and the good efforts that everyone has always been doing historically with respect to EEO and non-discrimination. But is it time to maybe sort of reassess sort of what you're doing and how you describe it? You bet. So that's my big takeaway. With that, I'll turn it back over to Sarah and Farnaz. Thank you.
Well, thank you so much, Brian. That was very insightful. That same executive order that Brian just outlined also specifically addresses institutions of higher education. And the executive order is actually a little more carefully worded than is being represented perhaps by the news, because the executive order targets essentially DEI and DEIB programs that can violate federal civil rights laws. And presumably not all of these programs do violate federal civil rights laws. But with respect to this executive order, the administration is focused on very large institutions of higher education, especially those with an endowment of $1 billion. So if your institution just made the threshold of $1 billion, you may not want to advertise that in your materials regarding your institution. But with respect to the administration, the Attorney General is supposed to issue a document and outline the principles with respect to investigating institutions of higher education, as well as identify 9 targets. The Attorney General is also supposed to issue joint guidance with the Federal Department of Education regarding the Students for Fair Admissions case. And we'll go over the department's guidance, although it's not joint guidance. But one thing to pay attention to, because I know there's a lot of concern regarding curricula and academic programming and how this executive order would impact that. And this executive order does have a First Amendment safe harbor. And the First Amendment safe harbor really does focus on teaching faculty. So people who are teaching at your school as part of a larger course of academic instruction can continue to, under the First Amendment, advocate, endorse, and promote the employment practices and the contracting practices that this executive order prohibits. So this is, the First Amendment still applies, and there's an acknowledgement in this executive order that that First Amendment still applies. So with respect to the Dear Colleague letter that was issued last Friday on Valentine's Day, it has a very different interpretation of the Students for Fair Admissions case than the last administration. And it's important to note that it was not jointly issued, but with the Department of Justice. And it's also important to note that it's very far-reaching. So the Department of Education is stating that this guidance applies to all K through 12 schools, all colleges and universities, and also state departments of education. And one reason they may be targeting state departments of education is if state departments of education that receive federal financial assistance are imposing DEI requirements or imposing requirements that run contrary to this guidance, then the states may reconsider their practices as well. The other interesting thing about this guidance is that there's a footnote inviting comment. So if you have comments, I think that it's an opportunity to provide the department with some feedback and questions regarding how this guidance may apply in certain cases. So with respect to this Students for Fair Admissions, we all know that Students for Fair Admissions considered the issue of using race as one factor among many factors in a holistic review process with respect to admission. And the issue before the Supreme Court of the United States was admissions. But this administration is using the Students for Fair Admissions decision as a framework for how to interpret Title VI much more broadly. And they're seeing it as a framework for how do you can you use race as a factor in hiring, promotion, compensation, financial aid, scholarships, prizes, all these categories listed on our slide. But what's really interesting to note is that the guidance states federal law applies to all these facets, but historically, the Office for Civil Rights at the Federal Department of Education has not decided employment matters. Historically, the Office for Civil Rights has referred complaints by employees to the EEOC, and presumably that's what they would be doing with respect to compensation practices or hiring practices. And really, the bottom line here is that the department is really focused on disparate treatment. The Dear Colleague letter states quite a few times that you cannot treat individuals differently based on race and because of race. So that's the bottom line rule that would apply in these different scenarios. And the Federal Department of Education, even under President Biden's administration, was implementing some of this guidance, for example, with respect to scholarships. The Office for Civil Rights, with respect to race-based scholarships, allows schools to change the criteria so that they're neutral, so that anyone could apply for and obtain scholarships. So that is something that they have been doing consistently under the last administration, as well as this administration. What's interesting about this guidance, though, is that it's really focused on race-based decision-making and proxies for race. So, for example, this particular guidance document states that you can't use personal essays, writing samples, participation in extracurriculars as an indirect way of considering race. And it's interesting because Chief Justice Roberts, who wrote the majority opinion in Students for Fair Admissions, ends the majority opinion on this issue of personal essays and says that, yes, you can consider personal essays, but in considering them, you have to really focus on a person's experience, the adversity they overcame, and really what the person has done and not the protected characteristic. And so if you are going to use personal essays, writing samples, in the justification for that policy for using personal essays, there really should be justification that's focused on learning about the individual and how they have overcome adversity and not necessarily the protected characteristic. But this is what's really unique about this guidance. And I think this is why the Federal Department of Education's Office for Civil Rights issued guidance, is that this is a marked departure from the prior guidance. So there was prior guidance by the last Department of Justice and the Office for Civil Rights, and they actually encourage, right, these potential proxies for race. And so I think that this is the Office for Civil Rights opportunity to give colleges and universities notice of how they're going to interpret Students for Fair Admissions going forward. Because presumably, if you're a college or a university and you're currently under investigation under Title VI, you were following one set of guidance that was, rescinded, and now you need to know what the new standards are going to be and what the expectations are going to be going forward. So this gives you a little bit of clarity in terms of how this administration is going to be enforcing Title VI. There's, again, 14 days or until the end of this month to comply with this guidance, which isn't a lot of time. But I do think that the Office for Civil Rights would work with colleges and universities in voluntary resolutions and in opportunities to resolve matters amicably. I do know that with respect to some grants, that if the recipient of the grant is willing to divert the funding to permissible uses or uses that this Department of Education deems permissible, that in certain instances the department will allow for the funding to continue. So I think this is an opportunity to potentially seek more guidance, more clarity, and also resolve things through informal means. Now, Brian mentioned something really interesting about the False Claims Act that's being litigated with respect to contractors, and that's putting in a representation that is material in contracts regarding federal civil rights laws. Well, the only issue about informal resolutions with colleges and universities is that colleges and universities already make this representation. So every college or university that receives federal financial student aid under Title IV of the Higher Education Act, each one of those institutions enters into what's called a program participation agreement. And the program participation agreement is essentially the contract to receive federal student funds, including for loans. And as part of that program participation agreement, you specifically represent that you will, as an institution, comply with Title VI. And that is arguably a representation that is material to the contract, because obviously the Office for Civil Rights will investigate any institution that may have violated Title VI, whether through a direct investigation, which the Office for Civil Rights initiates, or through a complaint that the Office for Civil Rights may receive about an institution. So what I think we're going to see is that the plaintiff's bar is energized by this language of the executive order regarding the False Claims Act, and the representations already exist with respect to colleges and universities and their program participation agreements. So I think the plaintiff's bar will be looking at both informal resolutions where an institution is not admitting that they did anything wrong and OCR is not concluding their investigation. But even with those informal resolutions, OCR still issues a resolution letter summarizing their investigation to date, and also an informal resolution agreement, which becomes public once the institution has entered into it. And I think you have to be really careful about what's in the resolution letter and what's in the resolution agreement, because that will provide fodder for the plaintiff's bar. And then, of course, if you proceed to get an actual letter of findings from the Office for Civil Rights and enter into a formal resolution, then that letter of findings and those findings may be used in a False Claims Act. And just a quick, I think many people here know about the False Claims Act if it applies to your institution. But the False Claims Act allows a third party, a relator, a whistleblower, to file a lawsuit under seal. And then the U.S. attorney has the opportunity to review that lawsuit and to investigate. And the U.S. Attorney's Office may decide to move forward with that lawsuit and represent the United States' interest in that lawsuit and go forward with prosecuting the False Claims Act allegations. The U.S. Attorney also has absolute discretion to dismiss the claims and the lawsuit, or the U.S. Attorney's Office may decide that it doesn't want to pursue it, but will allow that third party, that relator, to move forward with the lawsuit. So in your negotiations with the Office for Civil Rights, you should consider the impact of the False Claims Act. And I think the Office for Civil Rights, in coordination with the Department of Justice, may be willing to potentially give you reduced liability or an assurance that you will not be potentially liable for a False Claims Act allegation if you voluntarily resolve the issue with the Office for Civil Rights. But that is yet to be seen. And what's interesting is Brian mentioned the Attorney General's memo. Well, the Attorney General's memo referred this executive order to the Civil Rights Division, which historically has not had anything to do with False Claims Act cases. It's the Civil Division at the Department of Justice that handles False Claims Act cases. So we'll see if the Civil Division gets involved, but this is absolutely something that you should broach, you should discuss with OCR if you are under investigation. And with that, I'll turn to Sarah Wake, who'll provide updates on the rest of the executive orders that have been issued.
Thanks so much, Farnaz. Can you hear me okay? I'm having some audio trouble. Okay, great. Hi, everyone. I have just a couple minutes to go through the massive host of executive orders and dear colleague letters that you've been handling over the last couple weeks. So let's start with NIL guidance, so name, image, and likeness guidance. As you probably know, there was guidance issued at the end of the Biden administration that said that the Office for Civil Rights will consider compensation provided by a school in connection with a student athlete's name, image, and likeness as financial assistance provided by the school, and that as such, OCR would look at it as compensation under Title IX, and the compensation had to be proportionate and made when it's made available to males and females. The current Department of Education has said that NIL guidance is no longer in effect. And I just, without making any commentary that will end me up on some type of watch list, I just wanted to read the Department of Education's Acting Assistant Secretary's thoughts as to why the prior guidance on NIL is now gone. He calls the guidance from the Office for Civil Rights, the prior guidance, overly burdensome, profoundly unfair, and going well beyond what agency guidance is intended to achieve, and that the guidance was made without credible legal justification. So that was his thought on OCR's guidance. And as of now, the NIL money from a school that's provided directly to a student athlete, if your school does that, is not considered financial aid, at least by the Department of Education. But I think it remains to be seen whether the Department of Ed will come out with additional NIL guidance or whether this will continue to play out in courts or potentially in front of Congress. Moving on to the 2020 Title IX final rule. You all know this, I'm sure. It's back. You should not be operating under the 2024 regulations. You should be using the 2029 Title IX final rule. I'm sure you all know that. The part that I think is creating confusion for my clients who I'm talking to about this is that in the Dear Colleague letter about the 2020 Title IX final rule, it says, quote, open Title IX investigations initiated under the 2024 Title IX rule should be immediately reoriented to comport fully with the requirements of the 2020 Title IX rule. I've had a lot of folks asking me, does that mean that our schools' investigations that are currently open under our Title IX procedures need to revert to the 2020 final rule, or does it just mean the department's investigations that are currently open? Farnaz and I agree and have consulted with folks who I think can speak to this in terms of how the department would view this. We think that language means that it's both a school's investigations and any open OCR investigations that would need to comply with the 2020 Title IX final rule, which that's a big deal. If you have open investigations right now that are not proceeding under the 2020 Title IX final rule, you should think very carefully about what you would need to do to revert that process to comply with the 2020, the policies and procedures that you had in effect for 2020. So moving on to gender ideology and including the NCAA. So I think the key takeaway here is there's a new executive order that's having tentacles even outside of the higher education context, but the order was issued on January 20th that says, it's called the Defending Women from Gender Ideology, Extremism, and Restoring Biological Truth to the Federal Government order. It says that the policy of the U.S. Is to consider there only to be two sexes, and that it's the immutable biological classification that you were born with, so either male or female. The order then goes on to say that you have an obligation to ensure that intimate spaces designed for women are designated by sex and not by gender identity. So there was also a requirement that any guidance issued from the department or other agencies that's inconsistent with this must be rescinded, and it has been. Something that Brian and I were talking about prior to joining you all today is that the EEOC just moved to dismiss its own lawsuit that it brought on behalf of a worker allegedly fired for his sexual orientation and gender identity. And the reason that the EEOC moved to dismiss its own case is that they think that the case conflicts with this particular executive order. This is, of course, interesting given the Supreme Court's holding in the Bassett case that firing someone for being gay or transgender violates Title VII. But I think this is very clearly signaling to us what the EEOC's enforcement priorities are going to be. Many of you have state or local laws that pertain to discrimination or harassment on the basis of gender identity. I think you need to still obviously be carefully considering those laws and be looking at your policies and procedures and the definitions contained therein to think about how you support your campus community, comply with local and state law, and also take this executive order into consideration. Related to this, after this executive order came out, the NCAA revised its policies related to competition in women's sports. And so the new policy of the NCAA is that competition in women's sports is limited to student athletes who are assigned female at birth only. So student athletes assigned male at birth can practice with women's teams and receive benefits related to those women's teams, including receiving medical care. But the policy is effective immediately, and it applies to all student athletes regardless of their previous eligibility under the NCAA's prior transgender participation policy. Interestingly, regardless of the sex assigned at birth or your gender identity, a student athlete can participate, including practice and competition, in NCAA men's sports, assuming that they meet any other NCAA eligibility requirements. And if student athletes are taking any banned substance, which would include testosterone, they have to complete the NCAA's medical exemption process. So for me here, if you have athletic policies that refer to or mirror the NCAA's prior stance on this issue, I think you want to identify those policies and consider revising them to comport with the NCAA's new stance on this, while at the same time looking at your student athlete population and seeing, are there any student athletes who are impacted by this presently, and if so, how can we seek to support them in their participation in our school activities. Last but not least, anti-Semitism. So on January 30th, President Trump issued another executive order regarding combating anti-Semitism and also a fact sheet that went with it. This executive order ties back to Executive Order 13899, which is a prior executive order that he issued in 2019. And that prior executive order said that discrimination against Jewish individuals may give rise to a Title VI claim if the discrimination is based on that individual's race, color, or national origin. So Title VI does not explicitly cover religion, but saying that it can potentially cover discrimination against Jewish individuals if there is a tie to race, color, or national origin. This is very consistent, in fact, nearly identical to the Office for Civil Rights' recent guidance on Title VI and anti-Semitism, including under President Biden's administration. The new executive order requires agencies to look at different ways that they can curb or combat anti-Semitism. So the agencies have some time to consider what additional measures they can take to kind of enforce this. And an interesting part to me was this new anti-Semitism executive order says that the agencies have to complete an inventory and analysis of pending administrative complaints and lawsuits involving institutions of higher ed, where there's an implication of a civil rights violation related to or arising from post-October 7th, 2023 anti-Semitism. So if you have an OCR open investigation or investigation that was closed but tied to post-October 7th, 2023 anti-Semitism incidents and or a lawsuit related to alleged anti-Semitism occurring on your campus after October 7th, 2023, know and be aware that you will be on some type of inventory or analysis related to that incident. This includes any OCR matters that were resolved already. So just be aware of that. And for the lawsuit piece of it, if you do have a lawsuit related to anti-Semitism after October 7th of 2023 related to that particular issue, there is going to be a recommendation from the Attorney General in their report on whether they intend to file statements of interest or intervention in those lawsuits. I anticipate that in some cases they will do that. The last thing that I think is important to know about the anti-Semitism executive order is that it requires the Secretaries of State, Education, and Homeland Security to essentially brainstorm with each other to think about how they can educate colleges and universities about inadmissibility requirements related to immigration. So we'll pivot to talk about immigration in just a minute, but essentially the takeaway from the anti-Semitism executive order is that the heads of these agencies will be working together to figure out if there are additional measures that they can take against non-U.S. citizens who may engage in anti-Semitic behavior on campuses. So for anti-Semitism, my advice is, if you're not up to speed on the recent OCR resolution agreements on anti-Semitism, I would read those. I think they're very similar. I think they're instructive, and I think they're consistent with the position that this administration will take on anti-Semitism. So we have found a point of unity between the two administrations, and I think that we should all take that for what it's worth and look at the prior resolution agreements on anti-Semitism and look at lessons learned there. Key takeaways for me that I think schools are getting their arms around right now is that you can't just say we're not going to look at alleged harassment related to anti-Semitism or any protected class, I would say, because it's not targeted at a specific person. So schools in the past used to say, we're not going to open an investigation here because the harassment is not targeted on a specific person. I think the OCR would say that is not true. If there is harassment that's impacting someone's education environment, you need to look into it. There's also very clear messaging, at least from the prior OCR, that you can't ignore online harassment. So just because something's occurring on Twitter or whatever people use these days, X, sorry, that therefore you can't just say, oh, well, it's online, it's not face-to-face, so therefore we're not going to look into it. You need to do a case-by-case analysis, assess the behavior, determine if it's having an impact on your education environment, and if so, act. I think another thing that's really clear is that schools, you can't just look at one isolated incident and say, oh, that doesn't rise to the level of a policy violation here, and that's the end of the story. You need to look to the overall environment for the protected class. I think in this case, we're talking about anti-Semitism in particular. So even if a particular incident doesn't rise to the level of harassment, you need to look at the totality of the circumstances on your campus and see, is there a hostile environment, in this case for Jewish students, but I would say for any protected class on our campus that we need to address. In theory, schools should have already been doing this, right? This is why we have coordinators who track trends across campus. But I think this is now very much been made clear to schools that you need to be looking at the totality of the circumstances. So thank you so much. I'm going to turn it over to my colleagues to talk about immigration.
Thanks, Sarah. So we're going to move away from DEI for just a couple of minutes and move into another directive out of the new administration, and that is immigration. And while we're certainly hopeful that we're not going to see increased immigration enforcement in the education space, we do think that there is a possibility, and we think it's incredibly important that everybody has a plan in place in case you do get a visit from any type of immigration enforcement arm. And so why this has become important all of a sudden is because of the protected areas guidance that's now been rescinded. Prior to the new administration in the Biden era, and even before, there was guidance that limited immigration enforcement actions in protected areas. And those included schools, places of worship, and also places where you would get any type of medical or mental health care treatment. And on January 20th, the new administration published guidance rescinding that protected area and said that they were going to use a common sense standard instead, and we're going to allow immigration enforcement on school property. And so while we do think that it is potentially rare that you might see immigration enforcement, we do want to walk through a couple of issues that we think everybody needs to be aware of on the off chance that you do have that interaction. I'll turn it over to Mike to walk through some of those.
Thanks, Mindy. So the reason why we think this is important is because there's a lot of organizations, particularly schools, that don't deal with federal agents in the way that other groups do. So in these types of inquiries, what we're talking about normally would be involvement with ICE and potentially other groups from Department of Homeland Security. But what they do, in essence, is they issue subpoenas, and they're also able to get warrants. And I wanted to kind of touch base on what those are, because they are different, and the response that is required is different. But one thing that's consistent among both of those types of processes is that you need to have a lawyer involved in responding to this. So one of the kind of benchmarks that we're looking at is related to FERPA, and FERPA, as most of you all know, prohibits the school from disclosing student records without the written consent of the parent or student. Now, there are exceptions to this. The one we're talking about here is in the issuance of a lawful subpoena. And what a lawful subpoena is it's several things. One is a judicial subpoena. What we're talking about in this instance is normally a federal action. So we're talking about an Article 3 judge, either federal judge or a federal magistrate, who is dealing with the issuance of a warrant. A subpoena from a regular judicial subpoena can be issued from a U.S. Attorney's Office or the Department of Justice. And what that subpoena is asking for is usually documentary information. That's different than a warrant, where a warrant has described probable cause to a magistrate or an Article 3 federal judge. and gives the federal government, meaning that agent, the right to go on the premises and extract certain information that's listed inside of that warrant. These issues are different when you're dealing with an administrative subpoena. ICE has administrative authority. ICE has administrative authority to issue subpoenas, and they're similar to judicial subpoenas, and then they're asking for documentary information. And they also have administrative authority for warrants. Now, everybody who has dealt with a subpoena knows that there is the issue of serving the subpoena, who receives the subpoena, and who is responding to the subpoena. In any answer to a subpoena, that answer is not required to be an immediate answer. There is a time frame of disclosure related to the subpoena. But sometimes, like I said in the beginning, when you're dealing with a federal agent, they'll come on the premises to serve that subpoena. And a lot of times that's different than the subpoenas that are received from educational institutions for a myriad of different types of litigation. And sometimes they can get a little bit overwhelming when you're dealing with ICE and they're here to issue a subpoena. That's why you need to have counsel involved and have that response go through counsel. There are challenges to both judicial and administrative subpoenas related to the validity of them, the scope of the request. Now, usually those challenges go up in federal court. They can be successful or unsuccessful. An administrative subpoena is something that potentially has to receive some type of judicial imprimatur in order to be enforceable related to FERPA. So if ICE comes on the property and has an administrative subpoena for some type of documentary information, the idea is that you want to slow down the process, hand it off to an attorney. And there are challenges that can be made through the administrative side that may end up through to the Article 3 judge. That may be the requirement, because it's not clear at this point, because if there are information related to FERPA, it may be required that that lawful subpoena has to be approved by an Article 3 judge. So the point being is that you got to take your time, got to have your counsel involved, and make sure that the response is done through that process. And obviously, Mindy's going to talk about this, but that's very different than a warrant, right? It's very different than a warrant, but subpoenas give you an amount of time to collect the information and deliver that information, and also make challenges to it. And so the last part of this is that when there's a valid subpoena requesting certain types of FERPA disclosures, the institution has to make reasonable effort to notify that student of the subpoena in advance before they comply with it, so potentially the student can raise challenges to that. And I will turn it over to Mindy, go over some of the warrant issues, as well as kind of look at some of the paperwork that you could potentially see in this instance, which we think is, I don't think it's remote, but at this point, I think there is, we have to be prepared for it, because there are situations where you can see ICE being interested in certain situations. So, Mindy?
Thank you, Mike. So what Mike was talking about was a subpoena for documentation. And the other way that you could have an interaction with ICE would be if they showed up on campus with either an administrative warrant for removal or a judicial warrant for an arrest or a search. And so it's really important to know the differences between those two different things. Administrative warrants that are signed by an ICE agent or an ICE judicial officer are not enforceable at that moment unless you give consent. And so basically what would happen is an ICE officer would show up, they'd have an administrative warrant for removal for one of the students on the campus, and they would ask for your consent to go into your private space. Especially in higher education, private space versus public space is really difficult to determine in some situations. We know dorms are private space. We know classrooms are private space. But you get into student unions and you get into the lobbies of classroom buildings, and it becomes more of a question of whether or not it's public or private. And so what we're telling higher education universities and colleges to do is to make sure that you have a plan in place where if immigration shows up on campus, everybody is directed to the main lobby of the administration building, which would be considered public space. And you guys make contact with counsel to immediately start trying to determine what type of a warrant you're actually dealing with. And so an administrative warrant, if they show up with it, and I'm going to show you examples of how to tell the difference between the two, you must give consent for them to go into the private spaces to locate individuals. And you should not give consent. At that point, you have the right to say, we do not consent to you coming into our private space. And at that point, those ICE agents have to leave or they have to remain on public space. Now, if they do have a warrant for removal and they wish to execute that warrant, they can stand on sidewalks, they can stand in public space and wait until they find that individual and exercise that warrant. What you can do is when you turn them away into public space, you can notify the students. And what we recommend is you read that warrant, you take pictures of it, you locate your counsel, you have a discussion with them, and then you can notify those students that their names appeared in a administrative removal warrant. What you can't do, and what we are really cautioning against and making sure people understand this, because we do think that this administration could pursue obstruction charges, is you can't locate that kid or that student on campus and tell them that they need to get away. You can't help them get off the campus. You can't do anything that would be obstructive to that administrative warrant being carried out. And so I really want to stress that, because I think especially in the educational space, you guys have a tendency to want to really protect the children that you teach, which is completely understandable. What you can do is say, we've seen a warrant with your name in it and we want to contact you or connect you with counsel, or we believe you need to talk to counsel to make sure that you have the right instruction on how to move forward with that. The other type of warrant is actually a judicial warrant, and that is signed by a judge, and it comes with very specific documentation that I'll show you in just a moment. And that warrant, actually, you do have to abide by it. If they show up with a warrant for arrest, we still think that you should go through the same process. You send them right over to the administrative building, you get your legal counsel on phone, and you have a discussion about what that warrant is actually looking for. If it is looking for an actual individual on your campus and you can locate that individual, you do need to work with the agents that are on your campus to locate that individual so that they can carry that warrant out. The other type of judicial warrant that you might see is a search warrant. And that would be a search warrant that is directed for them to go onto the campus and to take specific documentation that relates to any type of immigration issue that they have probable cause for a judge to issue the search warrant. In that instance, you also have to work with them because it is a valid judicial warrant. And there are definitely steps that need to be taken to make sure that you are complying with that and not acting in any type of obstructive fashion. And I'm going to show you examples because I think it's one of the best things that you can do is educate your staff on what to look for if ICE does show up on your campus. And so what you're going to see is different types of warrants. This one that you see right here is an actual, on the left-hand side where it says United States District Court at the top, and it says search and seizure warrant. This is what I was talking about with a judicial warrant. This is signed by a judge. You see it at the very bottom. It says U.S. Magistrate Judge. Sometimes it'll say District Judge. And that is a judicial warrant that will either be an arrest warrant or a search warrant that will allow them to go into your private spaces and take care of what is allowed under that warrant. And the search warrant will be very specific as to what they can take. You compare that to the other side of the screen and you see that this is actually an administrative warrant. And you can tell the differences right away. And that's why it's important to get these in front of your staff so that they can see what to look for. This has no court information at the top. You don't see United States District Court. And at the bottom over on the right-hand side, it's signed by either an immigration officer or an immigration judge, but it is not signed by a federal judge or a federal magistrate. If you get this type of warrant served on your campus, this is when they don't have the right to come in unless you give consent. And you should not give consent under this warrant. And so we think it's important that Sarah, did you just lose me? Can you still hear me?
Mindy, is that going on in your office? I can take it over from here.
I don't know if it's on mine or if it's on somebody else's. Sorry about that. I don't know what that feedback was. I just want to emphasize the signatures on these really quick. Sorry for that pause. So this is what your judicial warrant signature will look like from a magistrate judge. And you'll see that that's very different than what it looks like from an immigration judge. So one other quick topic, and then Mike, I'll let you jump in to wrap up whatever I didn't. The other type of immigration issues that you can see within the school is an I-9 audit. And I think that people need to make sure that all documentation for all employees in your space is up to date and current, so that if an I-9 audit is done of your institution, you are ready to provide the necessary documentation and work with the immigration officers that are making that request. Mike, I'll turn it over to you to clean up anything I missed.
No, I don't think you missed anything, Mindy. I think really going back to one of the first things I said, when you're dealing with federal agents, in this instance, probably like an ICE agent, there is going to be an expectation of like immediacy of response. And apart from the search and seizure warrant or the arrest warrant, which are judicial warrants signed by an Article 3 judge, that exigency does not exist. So I just implore people and always our clients, like slow down the situation, take pictures of the credentials of these individuals, and then also take pictures of the warrants and provide them to your counsel to give you that type of advice. And so, happy to answer any questions. If anyone has any, we can follow up with this after the webinar, but it was a pleasure giving this to y'all.
Thank you so much, and thank you in particular to our immigration colleagues and to Brian. For what it's worth, I'll give a little plug to our immigration team. I've had them work with several of my higher ed clients to kind of do a training akin to what they just talked about, but in a little more detail. And they've done a really terrific job that I think has brought some comfort to a lot of schools. So thanks to everyone for the work they're doing. We'll be respectful of time. We have a list of the questions that people have sent. Someone will get back to you on those questions in the next day or so, but we appreciate everyone's engagement and hard work during these difficult times, and however we can support you, we're here to do that. So thanks so much, everyone.